Over. Welcome to the Weltman Ask a Pro series. The Weltman Ask a Pro series provides best practices across the entire collections process. Today's topic is navigating the currents of marine and recreational defaults. Watch your email or check out the Weltman website for future segments in the series. This is a joint presentation of Weltman, Weinberg & Reese and the National Marine Lenders Association. Weltman is a nationally recognized full-service collections law firm with approximately 60 attorneys and over 500 total employees. We represent nearly every type of creditor, including some of the largest financial institutions in the United States, consumer and commercial collections, collateral recovery, and real estate default. The mission of the National Marine Lenders Association, or NMLA, is to promote, improve, and grow the recreational marine lending industry within the United States. Over the organization's 40-plus year history, the NMLA has educated their current members and prospective lenders about healthy marine lending practices. Their annual Marine Lenders Conference and the Lenders Workshop are paramount in this educational process. As a side note, myself and Tom Thornton of M&T Bank are presenters today, and also our regular panel members at the annual 3-day Lenders Workshop in Orlando, Florida. This workshop, which is held every March, is the best source of education and training in the marine and RV lending space. If you have a chance, check out the NMLA website and consider becoming a member. Now I'd like to turn you back to Chris, who will be taking care of our moderating today. Chris Kimes from Weltman. Chris?
Thank you, Stuart. It's great to have everyone on today. Super excited. I think we're about 150 attendees. That's great. So my name is Chris Kimes. I'm the Director of Business Development and Marketing for Weltman, Weinberg & Reese. And before we get started, I'd like to kind of introduce the panel. You will notice we don't see Tom today, but when we get to Tom, he is on the line. So Stuart, do you want to kind of kick it off since you started and kind of introduce yourself?
Yeah, good afternoon, or good morning, actually. Stuart Best, I'm a partner here at Weltman, Weinberg & Reese in the complex litigation and also recovery area out of Michigan. Take care of all the complex matters as well as kind of a specialty in marine as well as RV lending and recoveries.
Great. Stefanie?
Hey, good morning, everyone. I'm Stefanie Collier. I'm an attorney here at Weltman. I am out of Indianapolis and also work at the complex litigation group. I handle all things repossessions and replevants, especially here in Indiana, but also nationwide as well.
Nick?
Yeah, hi everyone. My name is Nick Rohner. I am here in our firm's Cincinnati office. Like Stefanie and Stuart, I work in our litigation group. I do a lot of replevant work. Kentucky, Indiana, and Ohio. And I look forward to talking to everybody today.
Thanks, Nick. Thanks, Stefanie. So I guess heard but not seen today. Tom Thornton, you want to introduce yourself?
I have a face for radio, yes. Tom Thornton, M&T Bank, Senior Vice President over repossession remarketing of our consumer portfolio, which consists of auto, marine, and recreational finance products.
Thanks, Tom. And it never fails. You can rehearse all you want, and then you have technical issues right before. So, thanks for joining, Tom. Really appreciate it.
Thanks for having me.
Yeah, of course. So kind of before we get started, I'd just like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session today, so please submit any questions that you have throughout the presentation on the question panel. I'd also like to share that at the conclusion of today's session, everyone that's joined today will get a copy of the recording because this is a recorded event. And we're also going to ask that you fill out a survey at the end just to help us get better to deliver the best content to you. So there'll be a brief survey at the end. So before we jump into the content today, what is Ask a Pro? What we've done here at the firm is we have polled our clients and our attorneys to come up with questions that oftentimes come up. And today we're going to cover many of those as we navigate the currents of marine and recreational defaults. But these are just some of the questions. So again, ask questions as we go. We're going to bounce between a few of the attorneys that we have on the line today on our panel. And then also we're going to bounce some things through Tom giving us a servicer's angle. So without further ado, let's kind of go to the first question. I think Stuart's going to handle this one, but how do you perfect a lien on a boat, RV, and or trailers? Stuart, you want to take that?
Sure. We're going to talk mainly about boats today, and in this section, boats across the United States, each state has its own difference in how you perfect the lien. There is two different ways in which a boat is handled. First thing you look at is the titling, and then there's the registration. And then lastly, we try to use that system in which to perfect the lien in the boat to protect the lender. The boat itself in different states. So you look at the hull of itself, just the boat. Certain states use a UCC filing or Uniform Commercial Code. Some use a DNR or a different term for the Department of Natural Resources, whatever that may be, via state. And some use the Secretary of State, similar to titling of a vehicle like a car. And so when you're perfecting the lien, you have to figure out where that boat is located, where the contract is written, and find out how to perfect the lien within that state. Next slide, please.
Sure. And Tom, do you have any thoughts there?
No, because Stuart had us all covered off, right? The state, I wish they would all go to one database in managing their business, but we look at engines, outboards, trailers. It's all difficult. It's knowing your state law and certainly having contacts with them to manage these processes.
You need to back up one slide. We skipped ahead. Just back up one. So in certain states, the trailer, if you're talking a trailerable boat, which is smaller, there is no title. It is registered, however. The state wants to put a plate on it, and of course that's how they collect their fees, is not titling it, but they register it. And then Michigan, for example, has a permanent trailer license. So once you get that, that transfers owner to owner. There's no registration for the trailer. Other states, again, you look to state by state, and this is, I'm going to harp on this. You must look to the state rule as far as how you're going to take care of that boat and perfect your lien. Again, with the titling, it's some states it's UCC, some it's DNR, and some it's a state lien. And again, this is just the trailer. And then lastly is the engine itself. If the engine is a onboard engine or inboard or an IO or inboard outboard, you don't have an issue. It's part of the boat, except when we get into mortgages, which we'll talk about. In a outboard scenario, the outboard is many times liened and owned differently. It has its own engine number. And I'm going to also use a term that I'll be using throughout the day today, or all of us will. We all know that cars have VINs or vehicle identification numbers. Boats have HINs or hull identification numbers. They're usually located in the back right corner, and important starboard, I'm not going to go there, but the back right of the boat usually has the HIN on it. It's also buried at one or two other places within the vehicle, but the engine, if it's an outboard, has its own motor or motor ID number, which is separate and different. So if you're titling and or taking a lien, you want to make sure your lien is perfected on the boat, your lien is perfected on the engine if it's separate, and lien is perfected on the trailer. The worst phone call in the world is from the repo agent. We'll talk about going, hey, I got the boat, but the trailer's not on your lien, so therefore, how are we going to get this thing home? So we've had to do strange things, which we'll go into in a little bit. And then lastly, our next slide. There is a thing called a ship's mortgage. Now, a boat can also be registered or is called a documented vessel. And you'll hear us talk about this a little bit today as well. A documented vessel is a lien and a titling that's done through the Coast Guard. A documented vessel must be at least 5 net tons. That's not weight, that's displacement. So if you know the difference, go back to your math class and from years ago, but that's the displacement of the vehicle, a minimum of 5 net tons displacement. And that way, at that point, you can register it in essence and title it with the Coast Guard. What this means, it's a national system, kind of like Tom just mentioned, we'd love everyone to go to, but this is only for large commercial vehicles, vessels, 5 tons or more. You can do this in recreational as well, but if it's a fishing boat, for example, a commercial fishing vehicle or vessel, it must be federally documented. The advantages here are, 1, it's a national system. Number 2, it's a constant system. You can get the registration information directly from the Coast Guard. And then it's also internationally recognized. So if this vessel is leaving the United States, that Coast Guard registration or documentation protects you. And also we'll talk about ship's mortgages in a bit. That's how you lien the vehicle or vessel once it's under documentation. Certain countries will only recognize the Coast Guard documentation. Some states registration are recognized in our local, like Bahamas, Canada, Mexico, places like that, they'll recognize the state registration as well. There are certain restrictions on this, and an overall thing that I'm going to say, do not ever, and a lot of my clients do this and I yell at them all the time, do not ever let the borrower handle the registration, titling, and the perfection of your lien. You're asking for trouble. Practice tip number one, do it all in-house if at all possible. If not, check the NMLA website, and there's boat documenters that'll assist you and walk you through the process on state-by-state level for a small fee. Lastly, if you look at the bottom of this slide, beware of fraudsters. If you type in United States Coast Guard, you will get at least 10 to 15 sites that are all fake. They are really good. They look like they're the Coast Guard site. They are not. So you got to go to the one that says .gov and make sure it says something else, not something else plus .gov. You got to get the .gov site and it says this is the real site or something like that from the Coast Guard. If not, you're going to pay a couple $100 for something you can do free on the Coast Guard site or for a nominal fee. Make sure you're using the Coast Guard site. All right, next slide.
Yeah, that's good information, Stuart. And no yelling at the clients, please.
Oh, I do it all the time. My job.
So the next one, I think this is definitely going to get some questions. So after a borrower defaults, what steps should a lender take to protect its rights, and when should it choose replevin over self-help recovery? And based on the introduction, Stephanie, I think this probably is right in your wheelhouse. You want to take this one?
Sure. Thanks, Chris. Yeah, so I always tell clients before we even get to the repossession or replevin stage, you've got some homework to do. So let's confirm that our consumer is actually in default. So what is default? How is it defined? We're going to take a look at our loan agreement, take a look at your payment history. Let's make sure we confirm that there is an actual default. Is it an insurance lapse? We're going to make sure that, again, we've got that documented. If there's a requirement to send out an insurance notification, we're just going to make sure we've got all of our ducks in the row before we even proceed ahead. Stuart just went over lien perfection. That's always my next step, is making sure we've got a properly perfected lien. We've got all of that. So then we're going to look towards, I always ask clients this, is the collateral even worth repossessing? Is it worth the cost or the cost of replevin? Because it does get expensive and it takes time. And sometimes the answer is no. You're going to look at, what are we trying to repossess here? What are we trying to get back? Is it an older model jet ski, an older model boat? Maybe running a value on it is if maybe we know it's in disrepair or it's not functioning. Why do we want it back then? Because then it's going to cost us more money to try to pick it up and then sell it. And what are we going to get at the end of it? So in those cases, I always recommend, let's look at the money judgment part. Perhaps we just proceed ahead and sue on the balance that our consumer owes us. Again, check for, before we get started, check for any SCRA, run a search, make sure that your consumer's not in the military, run a bankruptcy scrub. We do those in-house too. Make sure, your consumer's not in an active bankruptcy or that your loan hasn't been discharged. And then always review state law. Stuart touched on this with the lien issues or the titling issues in each state. Each state has their own set of rules that keep us on our toes. We've got to make sure that we know whether we need a right to cure even before we start the repossession process, or maybe there's a redemption rule that we're not aware of. In some states, Louisiana has its own set of rules. It is a wonky state that you may not even be able to repossess in it, depending on what type of lender you are and what type of collateral you've got. So making sure you know which state you're in and the rules are really the great tools before we even start the process. So Chris, to then think about whether you're going to do self-help repo or replevin. Sometimes it just depends. So self-help repossession, the Uniform Commercial Code, allows us to repossess without judicial process, without a court order, if we can do so without breaching the peace. So what does that mean? That means if we can take back the collateral without having a threat of violence, or without our consumer, saying, don't take it, and potentially escalating violence. if we can take it back, maybe it's sitting on the side of the road or somewhere accessible that we can get to or our agent can get to, that's when we can do so without breaching the peace. Where it gets tricky with, talking about marine items, and I've had these, cases where we've got a large vessel and maybe it's sitting in the very back of the marine and we can't get to it. There's, maybe 20 boats ahead of it. We cannot physically get to it. So in those cases, we're going to have to look at a replevin or the large RVs. I've had, the $400,000 all decked out RV that's sitting in a, it's usually they're stored in commercial warehouses. They're not sitting out on the side of the road that we can just pick up. So those are going to be cases that you're going to have to evaluate, where is it? Where is it stored? Is it something that we can get to? Or do we just need to move to a replevin? Chris, you were out at the used car week conference with me and the queen of repossessions and replevins, Amy Holbrook, giving a presentation back in November where we actually got this a response from a bunch of repo agents that told us, that they wish that lenders went legal faster because the collateral is, they know it's being concealed or it's being stored somewhere they can't get, and they just wish that lenders went to the replevin process faster. So, don't be afraid of filing a replevin or going legal. Sometimes it just gets you to the end result faster, gets you that court order where we can actually get possession back. And sometimes you may have to, just depending on what the collateral is and where it is.
Right. So it sounds like it's a no two situations are the same, and it's a very consultative type of situation to determine what the actual best recourse is. So replevin is solid, and price is going to come into, the cost is going to come in, that value of the collateral, right? Is that what I'm hearing?
Yes, definitely. Yeah, if it's a high value piece of collateral, maybe you want to go replevin right away. Especially if it's being stored somewhere, you want to get it back. That's something that it's going to have value to sell. But yeah, it's going to be, knowing where your collateral is and what it's worth is really important.
I do see some questions coming in. I think most of these will be picked up later, so I'll hold off on interjecting those just so everyone's aware. Stephanie, thank you for that. Let's go to the next question that we normally have.
Actually, real quick, Chris,
yeah, sure.
I'd like to hear Tom's input on kind of what M&T does.
For sure.
Yeah, self-help is always the best solution in these instances. Replevin for our treatment plan ourselves, right? Certainly we go to a certain amount of days for delinquency, look for the opportunities to repossess, as Stephanie indicated, with SICRA, bankruptcy, liens. And there are some instances that will actually repossess based on strength of contract, but it all depends on what your appetite for risk is in these instances and how confident you are in these instances that it's not titled under somebody else. And then we go through our treatment plan through assignment of repossessions to charge off. And if we're unsuccessful in recovering that collateral at that time, we go through a recovery treatment plan, and it goes through our internal recovery and see where our opportunities and then we quickly accelerate to our legal team for assignment. And not only in the instance of replevin, because we don't always know where it is, and a lot of times that is going to be crucial to recovering it, we act on a replevin and judgment at the same time. And in those instances, if we can't get the customer to court, and there's no debt or jail at this point, though we can try and force them into that, and they don't show or don't disclose, or they don't know where it is in the event that it may be a straw purchase third-party thing, we know at least our judgment's going to have some impact on our customer, where the potential of returning that collateral comes up in the near future.
Something Stephanie didn't mention as well, certain states are dual action, some are single action. Certain states you have to go after the collateral first. Certain states you have to go after the lien first, or the note first. Certain states like Michigan, we go after both. We take off after the collateral and obtain judgment at the same time. If we collect the collateral, we simply apply it towards the judgment. We've had to educate some of the judges on that, that we're going after both, and we'll have to credit. Now we put it right in our judgment to state that.
Yeah, and certainly to think about what net equity analysis looks like in determining. I mean, our portfolio consists of some older boats in some instances, and a few of those lien issues out there, impound, mechanic lien, of course, the cost of referring this to a legal partner. There's been times where we do not exercise our right on the security interest, and that's when judgment then comes into play immediately.
Yep, good insight there. So Stefanie, to stay with you. So as we're moving through the process and someone is looking to determine, what's the best contractor for me to take the next step in managing a qualified recovery contractor, can you touch a little bit on that, please?
Yeah, sure. And I'll lean on you, Tom, on this one too. But yeah, I think just confirming experience here is so important, especially with the type of collateral. I mean, you can't have someone that's got knowledge in cars going after these big vessels, right? We have to have somebody with experience, with marine, with the big RVs, any type of commercial toys that we may have. It's really important. So looking for an agent that specializes in it. And then even if you do get it back, looking for an auction house that specializes in it. I've had to do searches for clients to make sure that we've got the right type of auction to sell our type of collateral, especially with these big vessels and big RVs, because we want to make sure we get the most value out of it, that we're selling it in a commercially reasonable manner. But yes, just in general, when you're looking for a recovery partner, and making sure you're confirming, again, that there's experience, reaching out, making sure you get referrals, confirming that they're properly licensed and in good standing. I'm always shocked when I look at repossession agents that aren't in good standing with the Secretary of State, simple things like that, and then making sure that they're properly licensed and bonded. Those are always things that I kind of go through my little checklist to make sure that we've got at least an agent that's, in my opinion, in good standing. And then I will have Tom weigh in on anything that you might be looking for when you're trying to pick a partner here.
Yeah, certainly from regulatory oversight, as we have to vet our vendors out. There's a rather robust program in having to accomplish that. There's anywhere between 800 and 1,100 qualified repossession agents in the United States right now. We run our model with direct agents that are local to our footprint, as well as forwarding and skip agents that are out there. And again, the vetting process is going to be important. And, with rate schedules and trying to avoid disparate treatment in costs and expenses, the vetting those out, making sure that our rate structures are maintained. And we go find agents that are specific to certain collateral. And in the event of marine product, the names like National Liquidators, Rick Obey, Marina Mile, and several others that are out there specialize in large boats. And they also have repossessions that we coordinate with brokers that, while they don't have the faculties or facilities to repossess boats, they do the state required or federal required processes of repossessions. And we utilize our broker consignment networks because they'll eventually transport the boat and sell it for us in those instances. And those specialty auctions that are out there for the smaller trailerable boats, and maybe even no trailers that were with them, the specialty auctions between National Power Sports, Mannheim Auctions, Odessa Auctions, America's Auctions, Cranky Apes are all solid solutions to moving that inventory. It isn't an absolute auction process. Your remarketing department should be product experts in these instances and utilize the auctions expertise for valuations. And certainly for all those auctions that I mentioned, with a few independents that are out there as well, is they know their product, they have buyers for it, and they're successful in moving inventory. Unfortunately, in some instances, you'll find some very distressed product. It goes back to the net equity analysis to see if the value's there. But in those instances where, and these are true stories, right? Someone attached a chicken coop to an RV, someone was smuggling drugs and illegal immigrants through boats and have been shot out by the Coast Guard. I mean, all those instances occur, but there's a home for everything.
Right. No, understood. Thanks for that. Appreciate it. So we did have a question come in. I will defer. That is the Rock and Roll Hall of Fame behind me. Someone had asked that question. Just want to get that out there. Because I am from our Cleveland office. Just it was a question, so I answered. So I threw it in there. Well, Nick, we haven't forgotten about you. Nick, let's talk a little bit about storage liens. What should a lender consider there?
Okay, thanks, Chris. Okay, this is a great topic. It's a juicy one, everybody. It lends itself to quite a lot here. There are a lot of considerations. Probably a lot of war stories out there too for the people dealing with these over the years. It's probably would lend itself to its own webinar, this topic, but we're just going to hit some basics as we go through. So I think the first consideration for everybody is sort of a basic concept, which is watch your mail. At your institution, make sure that you have an expedited process to handle a piece of mail involving a storage or mechanics lien. Nowadays, these are still going to come in through the old-fashioned mail. And when they arrive, they need to get to the right person's desk as soon as possible, because time is always of the essence when one of these notices is received. And I think, and before going further into that, I also want to step back and say that, you know, the notice, state law is going to govern most of the storage and mechanics liens that you're going to see, and every state is different. Just like Stuart alluded to and Stefanie's alluded to, in this area, state law is crucial. And unfortunately, and Tom alluded to this, I wish everything was uniform, but it's not. And so because of that, knowing the states where you lend and the general mechanics and storage lien rules is a good idea. And you don't need to know the nuts and bolts of those necessarily. I mean, that's what we're here for. But just having a general idea, like for instance, is a state a sort of garage friendly or storage facility friendly state, like Indiana, for example. I practice in 3 different states. Indiana is a very garage friendly state as far as the law. Mechanics liens. Is it a creditor friendly state? There aren't a lot of those out there, but Ohio, one of the states I practice in, is quite creditor friendly based on a Supreme Court of Ohio case from many decades ago. Or is it a state that's kind of up the middle? And that's like Kentucky, the other state I practice in. They kind of balance both interests, I think, pretty well. And so just knowing each state that you lend in and what the general sort of overview of the mechanics, what the philosophy is of the state legislature with regard to these types of liens is important. But getting back to watching the mail. So having somebody who can assess a notice when it comes in is very, very important. And then if an attorney needs to get involved, getting it into that attorney's hands as quickly as possible to review. I can't tell you how many times, get an email or I've gotten a call from a client and the auction has already occurred. And the auction was in the date was in the notice, and it just didn't get to the right person. And by the time it did, and it got to us, they wanted to know if we can do anything. And often you can't. There's very limited options at that point, and so that's why it's crucial. And then the best case scenario is you get it. It gets to the right person, and you're dealing with it. But any kind of delay could cost you, because storage fees, especially if it's a storage lien, are going to continue to accrue daily. So every single day that you wait and it's not resolved, it's just going to keep adding to the bill. So definitely moving on these as quickly as possible is probably the first consideration. The second thing is understanding when the notice comes in how the lien was created. Recognizing this is going to affect how you need to act. Usually you'll be able to figure out how it was created, whether it's a federal maritime lien or something created out of state law, by simply looking at the notice or the document that you receive in the mail. A lot of the notices actually cite the state statute in them, which is helpful. If it's a federal maritime lien that's being foreclosed through a federal court complaint, it'll be pretty obvious in the complaint that you're served with. And so again, knowing what where this is coming from is going to help you react. Kentucky is an interesting state in that they have a separate statute just pertaining to storage liens on boats. So whereas a lot of statutes, sort of the boat liens are kind of mixed in with the RVs and things like that, Kentucky actually has a special statute for boats being stored at marinas and how storage facilities can essentially foreclose on their lien through the court system. So there's an initial notice that goes out, but then that will be followed up with an actual state court complaint. So a financer will be served with a state court complaint, essentially foreclosing that lien, and then they'll be able to respond. Ultimately, the storage lien will take priority, but at that point, it's time to react and hopefully negotiate something with the marina to get your boat. So that's sort of the second consideration, is trying to figure out, and obviously you may need to review that with your attorney, but trying to figure out how, in fact, was this lien created? Where did it come from? The third consideration that I like to share is understanding the lien priority. So once we know where it came from, okay, so then what actually is the law in this state? How do we know, where do we stand as the creditor? Are we a senior lien in this situation, or are we junior to the repair shop, storage facility, or the marina? Okay, and so Stuart alluded to ship mortgages, preferred ship mortgages. One advantage of filing recording a ship mortgage with the Coast Guard is that lien is going to be senior to almost any type of mechanics or storage lien. So whether that be a federal maritime lien, unless there are these preferred maritime liens, which we won't get into, but a normal one for what are called performing necessaries on a vessel, such as storage or repairs, your lien is going to trump that lien. If it's a state court lien, same thing. Your federally recorded lien should trump that. But in a situation where we have a state court a state issued mechanics lien, and then your lien is simply recorded according to state law. So it's either on a certificate of title through the Secretary of State or one of the other manners that Stuart laid out. If that's the case, then everything is going to be governed by state law, and the priority will be determined by the law of that state. And so in most cases, unfortunately, I think the majority of states are going to find that as long as the repair shop or the storage facility has followed the procedure set forth in the statute, they're going to have a priority lien for the amount of the repairs they did or the storage that they've done, okay? And so because of that, again, it's very crucial that you act quickly in that situation, because the longer it gets strung out, if you're thinking about trying to contest it or something like that, you may not be in a great position to do that, and it's going to keep adding to the potential amount of the lien being held by the storage facility. And that leads into sort of the fourth consideration, is that you've got to be prepared to pay or negotiate very quickly. Again, because you're probably going to be, again, this assumes that the storage facility or repair shop has followed the procedure. Now we'll get into situations where they haven't, but if they follow that, then you need to be ready to pay them or negotiate something, because often, you get this, you get a large bill. Nobody wants to pay that, obviously. Maybe there are some questions about, well, how long has this vehicle really been, this RV really been there? Is this, is this really an honest bill here? Did they really do all those repairs? So maybe there's a question of that, a legitimate question. And so the best thing to do is contact them, see if you can get some more information potentially if there were repairs done. But even if, my advice here is even if get something slightly sketchy going on, even if maybe they embellish the amount of the repair bill or maybe the storage bill, is it worth truly litigating that, that lien in court? Because at the end of the day, it's going to cost you a lot of money to hire, one of us, and then by the time you get through the court process, the storage bills run up even more. You could even just flat out lose, and at that point you're left with a much higher storage lien to deal with, and so you're probably better off, and this is how I advise our clients. Normally you're better off to try to get in there and try to negotiate something reasonable. It's probably going to be more than you want to pay, and maybe it's more than what's even fair, but in the long run, it's going to cost you less, and you're going to get your boat out of there. You're going to get your RV out, which is ultimately what you want. You want to get it out of their hands and get it back into your hands.
What I've seen as well, in fact, while we're sitting here, I just got a text in from a client that had the same issue, is that they found out the unit was in a storage facility, and these storage facilities won't give you value. They don't give you not only valuation, they won't give you quality and what the vehicle looks like. So they will charge a fee for them to pull it to a place where you can go take a look at it to cover their insurance costs. This again goes back to Tom and Stefanie and our discussion about valuation.
Right.
And it's $200 for my client to go in and just look at the car to see if it's worth it. If you don't know your value, you don't know if you're going to pay the $4,000 in storage, but then is the $200 worth it to go take a look at it? And then if it is or isn't, I always recommended a client immediately send your repo guy out there, pay the couple $100 to look at it, make an informed decision. If it's decent and the bill is, as Nick just mentioned, is even close to being reasonable, pay it, get the damn thing back. The problem you get into, as Nick just mentioned, many times the bill for us is going to cost double or more than the amount that they're trying to charge. And it's typically $4,000 to $8,000 is where they're throwing at you, which is outrageous. We all know that. But at $4,000, we're going to do a replevin action, which is going to cost, and then you're going to get into, and then that bill is going to be higher. The last one is the most important. Negotiate, get ready to pay. And if you know it's a 1999 Honda Accord that's got 300,000 miles on it, why even take the phone call from the repo? Just move on. But
so Stuart and Nick, I'm hearing check your mail, act quickly, ask for assistance. Don't try to do this on your own. Ask your general counsel or reach out to an outside expert, and be prepared to pay and negotiate. Is that what I'm hearing?
Yep.
Yeah, okay.
That's right. I think getting an attorney involved isn't always required. I mean, I would first try to negotiate with the repair shop or storage facility yourself. And I think I would advise just the approach to doing that I've learned over the years in dealing with many of these places, is that they're not always the easiest to deal with. And so you can't come in like a bull in a china shop. You've got to tread somewhat lightly. I would take a friendly approach at first. That's what I tend to do. And so I think they're more likely to deal with you, because otherwise, I mean, I have plenty of situations I've dealt with, especially in rural areas where, I mean, sometimes they don't follow the law. Like in Kentucky, they won't have sent the required notice, but they don't care. I mean, they're not, and just because you come in saying, you didn't send us a notice and it's been 6 months and you never sent it within 10 days as required by the statute, they don't care and they'll just hang up on you, so you have to sort of take an approach to try to really resolve it, I think. And the same thing goes if you send it to an attorney. Sometimes an attorney will help. We've had certainly situations where I've gotten involved, and because I'm an attorney, it just seems to help sometimes with that, because then it's one step from going to court. And a lot of these places, they really don't want to go to court. But in the same vein, how your attorney approaches it is important, because the attorney also has to take, I think, a friendly approach, or they're not going to talk to us either.
Right.
So that all goes into it. But yeah, I agree with Stuart. That's the most important part, the most important consideration when it comes to these types of liens.
Tom, do you have anything you'd like to add here?
Oh, we could have a whole nother session on this, but yes,
I think we're gonna have to, but go ahead.
right. Have subject matter experts. What we built out in here is understanding the impound process and how the negotiation is. And if we're talking specifically marine, as we're a nationwide marine lender, a lot of these are in the backyard of dealers that we're associated with, and we look for those opportunities to negotiate. And their key word, right, in the last 5 minutes, you've heard negotiate, negotiate, negotiate. We have a 50-state matrix to see what our creditor rights are, and then we see where our opportunities exist. And we utilize the remarketing department with the default servicing, saying, again, what's this worth? What's this going to cost us? And the attorney network that we have is crucial to what our solutions are. And in these instances where there's no negotiation and it's a pretty hefty fee, and we're not talking about the ship's mortgage, just regular liens and impounds, and talked about some of them being fabricated, is that federal courts now recognize these secondary liens in a lot of states as unconstitutional. And while it may cost us a little bit more to go to federal courts, they recognize them and they'll wipe those liens off entirely in some instances, right? There's always going to be exceptions in there. So know your product, where those opportunities exist, build out employees who understand the art of negotiation and utilizing internal counsel as well as external.
Thanks, Tom. Yeah, makes sense for sure. Stuart, as we're kind of getting near the end here, you want to take this next one that's up on the screen? What are the unique issues regarding recovery as to boats?
Yep. So we just talked about the differences, and I'll detail that very quickly for you. A repossession is self-help. As Stefanie mentioned, if you can get it back yourself by sending out a repo agent, go for it. Once you can't get the vessel, or you can't get the vessel because of either it's locked away, you can't locate it, or for other reasons you want to go, then you move over to a replevin, which is the legal side. That's the UCC side and or the state law side as far as repossessions and replevins. If you do have a ship's mortgage foreclosure, if you have a ship's mortgage registered through the Coast Guard, as I mentioned earlier, if it's properly perfected, you still have self-help remedies. You do not have to go simply to the foreclosure process. You can use self-help to go get that vessel. But typically, these are larger vessels. Repossessing them is a little bit more dangerous. It's a little more difficult. And locating the vessel and or getting it off of a dock gets a little dicey. So then we go to a ship's mortgage foreclosure. A ship's mortgage foreclosure is a federal action, as Tom just alluded to, in the federal court. The difference here is that you list not only, you actually sue and what we call arrest the boat first. So it's kind of like a prejudgment execution, if you've ever seen those before. We go into federal court, we tell the court that the loan has been defaulted, we identify the vessel, we identify where it's at, and then we go in and we grab the boat using the Marshal Service. This is the fun part about these, and I say fun in two different ways. Number one, we actually do hire the U.S. Marshals, the guys that go do the DEA stuff as well. And the nice part there is they typically don't have issues. The last one I did, they came in with a boat and 5 guys, and they charge a flat fee. They come in waterside, dockside. If they feel it's a larger vessel, I've actually had them put a helicopter up for us before. And they charge you a flat fee. Miami's used to doing this. They have a flat amount. Different states have a deposit to initiate. This is after you get the court order to do this. This is not a repossession. They're not doing a repo for you. They're doing a court-ordered arrest of the boat. They go find that vessel. You tell them where it is typically. What happens is they get the boat. If anybody's on it, they politely get them to leave, which usually it's like a DEA raid. They love doing these because they're not getting shot back at, which is kind of cool. They go in, they arrest the boat, they physically take possession, make sure there's no contraband on board, make sure it's the correct vessel, and then they hand it over to one of two things, either to your repossession agent, who then becomes an officer of, they are assigned by the Marshal Service to hold that boat for you. Typically, they go hide that boat. The folks I use, they don't even tell me where it's at. They get that boat. Once the Marshal Service has turned it over to them as a houser of the boat under the U.S. Marshal Service, which has been tagged. Therefore, if somebody besides our repossession agent tries to touch that boat, they're under federal violation of law at this point. Call the Marshal Service back, and now they start arresting people. It gets very serious, but it's nice because it's very calm. Typically 99% of these, they walk in, people walk off, the boat's gone and it's disappeared. You then have it evaluated, you do a full survey of the boat, and then you go into court and finish it up, take your default, and then put the boat up for auction under the Marshal Service. But the Marshal Service also will use someone like National Liquidators in which to market and sell that boat. So you're not just putting it someplace and hoping to get a buck for it. You actually nationally sell that boat. To go back to the replevin side and the sale of the boats, we talked about the term, and Stefanie raised this quickly. I want to just flag something for you fast, which is commercially reasonable sale. That's a term that's used in the Uniform Commercial Code. What that means is not that you receive sufficient monies at the time of sale, it's how the sale was done. In other words, if you follow the process appropriately under state law, or as I'm just talking under ships, mortgage, foreclosures, under federal law, and sell the boat in a process which is commercially reasonable, the value or how much you received of the boat does not determine if that's a valid sale or not. It's the process. So, and what this does is that sets your deficiency, and I'm teeing up the next slide in just a moment, but that's teeing up how much you can get in fact, if there is a deficiency balance. So all the systems we're talking about right now are not only getting your collateral back, but then once you get that collateral back, making sure that it's properly handled so that you can proceed to your deficiency. Ships mortgage foreclosures are fairly expensive, I'll be blunt. You're going to add those to your balances. So your costs, your fees for the U.S. Marshal Service and for our fees to go get that vessel are going to be added to, as well as the storage fees, costs to repair that boat, etc. So again, you want to do a financial analysis. You're not going to do a ship's mortgage foreclosure on a small boat or an ancient boat that is not going to recover your fees for you. You're probably going to walk away and go after the debtor if you can. If your only remedy is your collateral, then yeah, you're going to go for it and see what you can do. But you want to talk to the attorney ahead of time and say, what's this going to cost me? Because you're getting into a bill that's going to be substantial, and you want to know that if you've got enough to cover all those fees plus some of the loan, because potentially we could eat up in the cost to do this in the ship's mortgage side more than the value of the boat. And as Thomas alluded to as well, you got to do that financial analysis, and you've got to do use the right people to do this, or the cost goes up. Your liquidator that you're going to be using on the back end of these will be a great help. We just had a quick war story. We had one that the client had with an auto repossession agent for 6 months to a year. Couldn't find the boat. Surprising. They were looking for a car. They didn't know what they were doing. They didn't know how to find the boat. We turned it over to one of our, the client called me and I said, hey, turn it over to these guys. They literally found the boat within 3 hours because they knew how to find the boat. Then the most amazing part was it was behind a locked gate. And not all of them do this. It's a fairly large boat. It was a 45, I think, foot custom boat. They put up a drone because that's what they carry. They know they've got to get behind gates. They stuck up a drone. They flew the drone down and find out the boat was missing an engine. So they also quickly valued the boat using a drone, called us back and said, hey, boat's got no engine. We know where it's at. Yet the hull is worth, at the time, 35 grand. And our loan was 10. So now with that pack of information we had to the client within 3 days using the right contractors, we knew it was worthwhile to go get that shell. And we did. So we had the boat actually within 3 days. So using the right folks, using the right processes, and knowing what you're doing helps a ton. Ships mortgage foreclosures. Somebody also asked a question if we have expertise in admiralty law. This area, we again work for lenders, so we can assist you in the area of not only perfecting the liens, but then collecting on the liens. General admiralty law, yes, we've got some general knowledge. We're not specialists in overall admiralty law, just in the areas of the lending side and what needs to be done.
Yeah, thanks, Stuart. I saw that question. Is that something someone could just reach out to us and you could help guide them?
Absolutely. And we also work with, again, with the NMLA as well. We've got a whole slew of attorneys that are admiralty specialties in different areas of admiralty law that we connect with. So if I get into an area that's outside of my expertise, I call in somebody. We have a whole slew of those that help us out all the time.
Well, you teed up our final slide very well. And there's been several questions regarding deficiency balances. So Nick, why don't we kind of close it out with you? You want to talk about what is a deficiency and what are some strategies to collect on them?
Sure, Chris. This again is a topic that we could probably talk for an hour about, but I'm just going to hit the basics. A deficiency is basically just the remaining loan balance after your collateral has been recovered and sold. But some of these principles also apply to if, let's say, I think Stefanie mentioned earlier, you get in a situation where you don't want to recover your collateral. It's not, the boat's not worth enough, it's not worth the cost, or you just can't find it. You can't find the RV. So, you're going to just pursue the money that you're owed. And that it can also be referred to sort of as a deficiency. But the idea is the same either way. And the first thing you want to do is you want to reduce that to a money judgment. You don't really have a lot of options to collect unless you get a judgment. You can certainly send letters, make calls, just basic collection activity. But until you go to court, you file a complaint, and you ultimately get a judgment, a money judgment, you can't enforce the judgment and then exercise these options that you have. The first option, probably the most common collection tool after you get a judgment, is a wage garnishment. Most people have heard of that. Almost every state allows them. There are just a few holdouts that do not. I believe Texas does not allow wage garnishments. I think North Carolina's one, and one of our footprint states at Weltman, Pennsylvania, also does not allow wage garnishments. What is a wage garnishment? It's basically a continuing. It's a continuing garnishment, meaning it allows you to, it orders the employer to remit usually 25% of a judgment debtor's wages, net wages, disposable wages after all the taxes are taken out and insurance and things like that, to the court or directly to the creditor, depending on the state, each pay period. And it's a continuing, meaning it doesn't stop usually until the judgment is paid. There are a few states that if you've got multiple creditors, multiple garnishments, they'll run in 6-month cycles. So every creditor gets 6 months at a time, like Ohio. But in most states, it just continues every pay period until the judgment is paid. Another option is a non-wage garnishment, which is often referred to as a bank garnishment, where that's sort of just a one-time, it's not continuous, just a one-time hit on somebody's bank account, and whatever's in there at the time the bank receives the paperwork, that is what is garnished. So it doesn't apply usually to the next deposit they make or anything like that. Now, there could be some states that do allow for those types of freezes and holds, but in general, bank garnishments are sort of one-time hits on someone's account. And you can keep filing them, but each one's sort of a new garnishment. The third one on the list here that's pretty prevalent are judgment liens. And that's basically filing a lien on somebody's property or properties in the county in which it's recorded. That's a great tool, and it's one that it may not pay off immediately, but it could pay off down the road, because it's going to, in most states at least, cloud title to that property. Now, keep in mind, there are exemptions in most states. Actually, almost all states have some kind of homestead exemption, which is going to exempt a certain value of that property. For instance, Ohio, for example, I think it's up to $136,000 roughly now per person in their primary residence. And so, but again, even if there isn't enough equity there, it'll still attach and it'll cloud title. And so it's going to cause a problem if they go to sell or refinance the property. And then, of course, when I mentioned exemptions, I think most people have heard about Florida. Florida is unique, and it's got a 100% homestead exemption for your primary residence. And so in that case, a judgment lien filed in a Florida county where you have your home would not actually attach. That's sort of the rule in Florida. That's why you do hear about celebrities going down to Florida and putting celebrities who are in debt go down there and put all their money into a house and basically can live there and not to be subject to a potential foreclosure on that house because of that 100% exemption. Something also just real quick, tenancy by the entireties is something to keep in mind with a judgment lien, is that if your judgment's only against one of two spouses and the property is owned by both and it's in a state that still recognizes tenancy by the entireties, and many states have abolished it, but some states still do recognize it, such as Indiana and Kentucky, then in that circumstance, your judgment lien would not attach to the property because your judgment is only against one of the two spouses. And then finally, I threw in here personal property levies. These are probably more common in states that don't allow wage garnishments, just because it is a way to create some leverage against the debtor. But it is literally what it says it is, which is levying on people's stuff. And so, it's not something, I mean, we have clients that don't allow us to do that. And at the end of the day, going and having the sheriff tag somebody's fridge or their couch is not really, what, it's not that effective, except it can create, it's not going to get money directly out of that. But it does, again, create leverage. And so if the sheriff does show up to tag somebody's property at their house, then that usually will result in a phone call, and then that we can maybe resolve it from there. So that's just like a quick overview of some tools that you have once you get a deficiency that's reduced to a money judgment.
Thank you, Nick. Really appreciate it. So as we wrap it up today, I want to ask first of all, thank you so much to the National Marine Lenders, Tom Thornton with National Marine Lenders and M&T Bank, our panel, Nick, Stuart, and Stefanie, thank you. But to the audience, if you could be so kind, we're going to poll real quick to find out how you heard about our webinar series, because we want to get stronger in getting our content out. Please follow Weltman on LinkedIn, Facebook, TikTok. There's a great deal of content that's out there for you. Remember, you will receive a copy of today's presentation. We will be sending you another little survey just to help us be stronger at communicating this content with you. But with that being said, thank you so much for spending an hour with us today. We really appreciate it. Have a great rest of the week and weekend. Thank you.